Good afternoon. Thank everyone for joining us today. I am with the Office of Public Government. My name is Sharita Berry, and I will be making the presentation on the Open Meetings Act today. With the panelists, we have our director, Ms. Nicole Allen, and we have Chief Counsel, Mr. Johnny Barton. We ask that you hold your questions until the end and send them via chat. Next slide, Ashley. The Office of Open Government is part of the Board of Ethics and Government Accountability. The office enforces the Open Meetings Act and regulations. The office contacts are Nicole Allen, which I just introduced. She is our director. Mr. Johnny Barton, who's our chief counsel. Myself, I'm an attorney advisor. And we have Kevon British, who is our IT specialist. Why do we have open meeting laws? We have open meeting laws. Open meeting laws require that, with notable exceptions, most meetings of a public body be open to the public, along with decisions and records. The law is designed to give the public confidence in decision-making activities of members of a public body. It allows the public basically to be informed about government operations. It allows for openness and transparency. That's why we have our open meeting laws. First, we have to, next slide, Ashley. First, we have to look to what constitutes a meeting. What is a meeting? What constitutes a meeting is usually defined by its purpose, to perform public business, and the number of participants. Is the purpose to perform business, and are there enough members present to constitute a quorum? If your answers to those questions are yes, then you have a meeting. All such meetings, unless specifically and legally exempted, are presumed to be open to the public, and the public must receive advance notice of the date, the time, the place, and the agenda. So the public needs to be aware of what's going on and when it's going to happen. Next slide, Ashley. What is a meeting as defined by the OMA? A meeting defined by the OMA is a gathering of a quorum of the members of a public body where the board members consider, conduct, advise on public business. Public business may include gathering information, taking testimony, discussing, deliberating, recommending, and also voting. Gatherings may be held in person, by telephone, electronically, or by other means of communication. And with the last sentence, I do believe we have all been conducting business electronically. Next slide, Ashley. Is not a chance for a social gathering where no business is discussed, or a press conference. If there is no quorum, then a public body can conduct a meeting. Unless established by enabling legislation, mayors or regulation, a quorum is half of the members plus more. Say, for instance, if you'll have a chance meeting, you're in a store, say Costco, on a Saturday, you run into other members of your public body, you guys start to chit chat. This is not considered a meeting, even though you may have all the members there. This is not considered a meeting, so you wouldn't have to worry about having a discussion in outfits at that particular time. Next slide, Ashley. Public bodies. Public bodies take official action by vote of its members, and these are examples of public bodies that are listed here. Any government councils, boards, board trustees, the public charter school, council, the Council of the District of Columbia, commissions, board of directors, advisory boards. These are all examples of public bodies. Next slide. There are also bodies that are not considered public, and that would be district agencies, mayor's cabinets, ANCs, District of Columbia courts, and professional staff of public bodies are outside the presence of a quorum. A quorum present, then you may have meeting at that point if a quorum is met. When is a meeting considered open? Public body meetings must be open to the public unless closure. A meeting is open if the public is permitted to be there physically, and news media is permitted to be there physically, and whether the meeting is live. That's when a meeting is open of those things. Next slide, Ashley. The public has to be properly notified of a meeting, and notice shall be provided when meetings are scheduled and when the schedule changes. Public bodies should give as much notice as possible, not less than 48 hours or 2 business days before each is greater. Must be physically posted in the school, the office, or place readily accessible to the public. And notice must be posted on the public body's website or the district government's website. And the district government's website is the central calendar. And you can get to the central calendar by going to www.open-dc.gov. Or you could contact our IT specialist, Mr. Kevon Bridges. You may contact him directly, and I'll give you his contact information towards the end. And he will be able to help you through that process if you are, in fact, the appointed administrative person to publish to the central meeting calendar. Next slide, Ashley. What should the notice include? The notice must include the time, the date, the location, and the proposed agenda. If there is going to be a closed session, the notice must include the OMA citation and state the reason for justifying the closure. And the citation is 2-575, where you would note your reason and your justification for closing the meeting. Next slide. What should the notice include? The following statement must be included at the end of all draft and final meeting agendas. This meeting is governed by the Open Meetings Act. Please address any questions or complaints arising under this meeting to the Office of Open Government at opengovoffice@dc.gov, OPENGOV office@dc.gov. Next slide. Some justifications for closing meetings would be court orders or statutes where the law requires a particular matter not to be disclosed publicly, negotiations such as you're negotiating the terms of a contract, to consent with attorney to obtain legal advice where you want to preserve your attorney-client privilege, trade secrets, training of staff, deliberations, investigations, testing and grading, and also personnel matters. These are some of the OMA justifications, and you can find that in Section 2-57B within the Open Meetings Act. Ashley? The protocol for closed portions of a meeting. When you have your open meeting and you're also having a closed portion, you have a closed executive session, you have to open the public meeting and establish a quorum. After you establish your quorum, move to enter into the executive session. The chair usually moves into moves to enter into the executive session, and then another member would second the motion, and they would also include the reference to the OMA citation justifying why you are having a closed meeting to justify the executive session. Then you would take the roll call vote, and if the motion passes, enter into executive session. Next question, Ashley. Next slide. Only discuss the matters referenced in the draft agenda. You cannot go into the closed session and decide to address a number of issues that were not listed and posted during or stated during the open session. Whatever reason you justified, whatever justification you placed on the notice, that is the only matter that can be discussed at that particular time in that closed session. You have to record whatever is discussed in the executive session, and after the executive session is over, you reopen the public meeting, you report publicly any official action taken in the closure, and you adjourn. So basically, you would have 2 separate meetings. Next slide, Ashley. There are recording requirements for the open meetings as well as the closed meetings. There's audio recording, video recording, transcripts, and detailed meeting minutes. You have to make sure, you have to confer with the vendor to make sure that there are no copyright restrictions with posting the minutes publicly. Publication requirements. Draft detailed meeting minutes must be publicly available no later than 3 business days after the meeting, 30 business days for Board of Trustees, and when it comes to the audio recordings, video recordings, and transcripts, the copies of the full record must be available no later than 7 business days after the meeting. Well, during our public health emergency, the publication requirements have been told that usually with the regarding the full meeting minutes and agenda, they may be voted on during the next scheduled meeting. But as I said, some of the publication requirements have been told due to the public health emergency. Electronic meetings. I know you all have learned a lot about electronic meetings in the past 7 months, but we must meet remotely during this public health emergency. Members can meet via video, electronic conference, or other electronic means if reasonable arrangements made to accommodate the public's right to attend are made. Meetings are recorded. All votes are taken by roll call, and all provisions of the OMA are adhered to that are not waived or told. Next slide, Ashley. Public health emergency rules. Physical posting at schools, offices, or other physical locations not required during the public health emergency. So these things are not required at this time. Recordings, postings are not required at this time. Recordings, the act is paused or told the time period for making a copy of the recording available during the public health emergency. We recommend that you make them available as soon as possible after the meeting. But even though the public health emergency has told the time period for responding to individuals who request the information, if you can obtain the information, you should make the information available to the requester and avoid necessary backlogs. So the tolling is to benefit you, where if you're not able to access the information, but if you have the recording readily available or the minutes available, you should provide those if requested. Next slide, Ashley. Public comments. Public comment is allowed only if the public body's enabling legislation mandates a period for public comment. However, a public body may allow public comment absent a statutory requirement to do so. Public bodies have the right to regulate the time and duration of public comment if they choose to allow them, unless the requirement is already spelled out in enabling legislation or bylaws. How do we cancel? How do we cancel a meeting? A meeting cancellation is a change in schedule, so the public needs to be notified that there is a cancellation. In most instances, it requires as much notice to the public as possible, but not less than 48 hours or 2 business days, whichever is greater, before the meeting was to occur. To establish a record, the electronic notice to the public of the meeting must state that it's canceled. So there is a duty to notify the public of cancellations. Next slide, Ashley. The Office of Open Government has initiated one lawsuit since the enactment of the office. The Office of Open Government is here to help everyone navigate through the process to allow for government operations to be open and transparent. So enforcement is not the first step that the Office of Open Government looks to. The Office of Open Government is here to help everyone navigate through and be compliant with the Open Meetings Act. The Office of Open Government may bring a lawsuit in the Superior Court of the District of Columbia for injunctive relief for any violation of the OMA before or after the meeting takes place. The court may order an appropriate remedy, such as requiring additional forms of notice, posting a meeting, or declaring action taken at a meeting to be void. So the Office of Open Government does have enforcement authority. So I'd like to close and let everyone know that the Office of Open Government is always here to help and help with trainings if your public body needs to have a particular training tailored towards your body. We will offer several in-depth Open Meeting Act trainings in 2021, and the trainings are usually posted on the open-dc.gov. The open-dc.gov is also a good resource if you need information regarding electronic meetings. There's a wealth of information there. You need information on how to record your electronic meetings. A lot of information, there's a wealth of information there. But feel free to contact any one of us, and we'll be able to help you as much as possible. And the next slide includes contact information for Nicole, for Director Nicole Allen, nicole.allen@dc.gov, Chief Counsel Johnny Johnny.Barton2@dc.gov. And the next slide includes myself and our IT specialist, Cherie.Berry1@dc.gov, and Kavon Bridges@dc.gov. And now, if anyone has any questions, we are excited to answer your questions.
There are questions in the chat and in the Q&A.
Okay. I said you have to reopen a closed meeting if no action was taken. For example, if the only point of the closed session was to provide information to the board on a personal matter. Yes, you have to reopen the open the open meeting again. You have to go into that session and report out what was discussed at that particular meeting to the degree that you're allowed to the information. But you have to the executive session and go back into the open meeting. And I hope I explained that to your understanding. And if you need more information or want a template or how to make that transition from a closed session back to the open session, I'd be more than happy to discuss that with you and your particular question. Will these slides be provided online? Yes, these slides will probably be on the open-dc.gov website in the near future. I don't see any other questions.
They're in the Q&A.
Okay. In the current virtual meeting, we found that the WebEx system doesn't allow us to log back into the
I can take that question, Cherie.
Okay, that's fine. I can't see the entire question.
Okay. I'll tag team with you and read them. So the first question is, in the current virtual meeting, we found that the WebEx system doesn't allow us to log back on to open session after we finish the closed session. What do you suggest we do in that situation? Well, in our virtual environment and the public health emergency, you should have recorded everything. So when you present the meeting after the meeting recording, just make sure that you go through that process and edit the final product so that you have the whole meeting. So it will be the public portion in the beginning on that WebEx meeting and the end. So if you need some technical help with editing, please reach out to us and we can help you do that. The ideal situation, which I noted in the training that we had at the beginning of the public health emergency, is to have two meetings, so two separate WebEx meetings. So you'd have the public portion of the meeting on one WebEx and then schedule a second one for the closed session. So keep that first meeting open, the public portion, and have your board members exit that meeting and go into the next WebEx meeting, which is the closed session. Conduct your closed session on the second WebEx meeting, and then once you're finished with that business, close it, and then have your members go back to the first meeting and, as Cherie just described, close your public meeting out there. So we found that's the cleanest way to do that. I see a statement from Friend McRivers. Where may this statement be found? I'm not quite sure what he's referring to. Maybe you know.
What statement may be found? Is he asking about the statement that needs to be at the end of the draft? End of the notice?
He said it was a slide, so I think so. I think he says that later. He or she, sorry. We'll be presenting, as Cherie mentioned, we'll be presenting all of the slides, so you'll be able to see them on our website on open-dc.gov.
Right. You can find. I believe you're talking about this meeting that's governed by the Open Meetings Act. Please address any questions or complaints arising under this meeting to the Office of Open Government at OpenGov office@dc.gov. You can find that. You can find that statement on our website, open-dc.gov. dc.gov.
Okay, Cherie, we have another question. If the Board of Trustees approves minutes at the next meeting, are unapproved minutes posted?
The draft meeting minutes are the ones that need to be made available and posted 3 days after the meeting has occurred. And once the next meeting for Board of Trustees is 30 days after the meeting has occurred, and the final full report of final meeting minutes are usually approved at the next full meeting. So at that point, the final meeting minutes should be posted.
Okay, next question. If you have a transcript of the meeting, do you still need detailed minutes, or can the minutes capture the action items?
It's up to you whether you want to post the transcripts or the detailed meeting minutes. Usually the transcript is more detailed and usually picks up more than the minutes, but you have to make the decision on if you want to post the final version of the meeting minutes or the transcripts. You don't have to do both.
Okay, next question. Are nonprofit organizations that are funded by the district and or federal funds under the rules of the Open Meetings Act?
No, they're not under the Open Meetings Act.
Okay, so that's all the questions.
I cannot see the questions. It looks like it's 11 questions, but I can't see them.
Yes,
there are a few more questions in the chat box.
Okay. Thanks, Ashley. Okay, the next question, is this new law for all nonprofit organizations in DC in addition to charter schools? I think you just answered that one, but just
No.
read it.
Right, it's not for all nonprofit organizations, no. What happens if you can't get a quorum to reopen the open session after a closed meeting? You can reopen you can reopen the first meeting, which is the open meeting, and you still have to have a quorum to vote to close the open meeting.
Right. So hopefully you voted in the closed session. You know, you follow the proper rules to re-enter into open session. So I understand that is probably a problem in this virtual environment when people cannot log back in or they log off. So that's something that you will probably need to note happen at the next meeting. But I mean, you're no longer conducting business, so it should not be a problem. Me just ending the meeting. But I'm going to toss it over to Chief Counsel Barton. You have anything else?
No, I think that's a little bit of some new territory for us, but that's something we can look at, and I'm sure there's a way we can find a meaningful solution to it.
Yeah, I mean, definitely, always keep records, and it might be something that you need to address in the next public meeting.
I can't see anything else.
Do you have a position on whether executive session minutes or tapes are releasable under FOIA? I guess I can take one. Yes, we do have a position. So, no, I mean, it would really depend on the circumstances, but in general, I would say no, they're not releasable under FOIA. Their deliberations, so, numerous privileges would apply. The way that the Open Meetings Act is written, it parallels the Freedom of Information Act exceptions. So you can always make a good, clear case that those records are not releasable under FOIA because of the FOIA exemptions.
The argument's been made that they would be exempt as under the other statute provision of FOIA.
That makes sense. Looks like we've addressed all the questions, Cherie, so we'll turn it back over to you.
Well, Ashley, can you go back to the 26th, the slide before the question and answer? Go back one slide. Here's my contact information. Again, cherie.deberry1@dc.gov. Thank you again for sitting in on the Office of Open Government's presentation on the Open Meetings Act. And as I said before, we're here to help, and feel free to call us or email us if you have any questions or if you need a particular training tailored to your particular public body. Thank you again.
Sorry, Cherie, I see one more question that came up in the Q&A. The question is, what if the meeting is closed for reasons that are not supported in the Open Meetings Act?
Then that meeting would be a violation of the Open Meetings Act. You have to make sure your reasons are justified and the reasons for closure is cited on the notice, and it will allow for the public to know that this particular closed session is under the Open Meetings Act. I don't know if you guys want to add anything to that.
No, I think you answered the question.
Are there any more? All right. As I said, we're here to help, and feel free to contact us at any time. Thank you again. Bye-bye.
I couldn't see the chats either.